Tonight, this episode of It's Your Call is one of our continuing series dedicated to facing the mortgage crisis, brought to you with the support of the Corporation for Public Broadcasting. Good evening, I'm your host, Roger Bowman. We've been hearing a lot of stories about tenants who are having their water, gas, and electric shut off without any notice. Some have had the sheriffs knock on their door and tell them they're being evicted. Tonight, we're going to cover the issue of tenants' rights, as well as expand on homeowner foreclosure information. For our tenant viewers, we hope to give you the proper tools to become more proactive in finding out if your landlord is actually the owner of your property and who exactly is, if the person you think is not. Our guests this evening are Enrique Acuna, Executive Director of the Inland Empire Latino Lawyers Association. Next, we have Eulalio Castellanos, Managing Attorney for the Inland Counties Legal Services. And finally, Alan Sims, Chief Executive Officer for the Center for Litigation and Consumer Real Estate Education. Thank you very much for joining us this evening.
Thank you.
Thank you. Thank you.
I'd like to invite you, the viewer, to call with your questions of our guests. The toll-free number is 866-367-5827. Enrique, why don't you start us out? Tell me a little bit about yourself and your organization.
Sure, Roger. My name is Enrique Acuna. I'm the Executive Director and Staff Attorney of Inland Empire Latino Lawyers Association. It's a legal aid organization that was founded, actually got started probably in the late 70s by some dedicated attorneys who wanted to expand legal services to the low-income members of the community that weren't being served by some of the other legal aid organizations. The organization became formalized in the mid-80s, 85, became an actual nonprofit. And, we focus on family law, landlord-tenant issues, civil defense. We do small claims cases, both defense and on plaintiff side. So, really just general legal aid type work for low-income clients. And I've been with the organization for a little over 2 years.
Wonderful, Enrique. Thank you. And Eulalio, how about you?
Okay, Roger. My name is Eulalio Castellanos. I'm the Managing Attorney for the Inland County Legal Services. We're also a nonprofit organization. We provide free legal services to low-income individuals. Our services include helping people from family law to housing law, public benefits, education law, areas that cover both San Bernardino and Riverside County. We have branch offices in Inyo, Victorville, Riverside, San Bernardino, Rancho Cucamonga, Riverside. And again, basically our services are free to low-income individuals.
Okay, and Enrique, you're an attorney.
Yes,
and Eulalio, you're an attorney.
Correct.
Alan, how about you?
My name is Alan Sims. I am the CEO of the Center for Litigation and Consumer Real Estate Education. It's a brand new nonprofit. My background, I'm a forensic real estate appraiser. And with that, the services we provide, it's a new service. We will be providing litigation support for anyone who's been involved in predatory lending. As you can imagine, it's a very big organization that we have planned. It will be up and running hopefully within the next 6 to 8 weeks. We need to get all our ducks in order here, but mainly what we need to get is the proper funding and recognition from the federal government.
Now, predatory lending, obviously, is something that's on everybody's mind, including this entire series. That's a big bucket. Describe for us what predatory lending means to you.
Well, for the predatory lending, especially in Southern California, we're looking for instances where the appraiser overvalued the home to make the whole transaction work for the mortgage. That's one avenue. The other avenue is bait and switch in the mortgage contract. So a lot of people tell me, I didn't sign this, or we didn't even go ahead and realize that my interest rate is now 14% when I thought it was going to be 5% for the rest of my life here. These type of instances are mainly consumer fraud, but a form of predatory lending because the lender acted as a predator without good faith to the homeowner when they had that transaction.
Does that include the type of mortgage that we've heard about called the liar loan?
Absolutely.
Explain what that is.
Well, what started with these loans, and again, the low document or no document loans started with, let's take a private contractor. And maybe they didn't have this type of record keeping that showed a good income, but they did have a good credit score. And having a good credit score kind of related that they were responsible and they also paid their bills. So with this, they were able to go ahead and put down the income that would justify the mortgage. Now, when that happened, there also was some discussion saying, well, it was good for one person, it should be good for everyone. And when that happened, the standards got a little bit laxed. So that's when they got creative, because the house that they were purchasing or refinancing acted as a lot of collateral and a lot of their supposedly income because of what they were purchasing at the time. And now we don't have that.
Alan, thank you. Now, Enrique, I want to ask, is your entity affiliated with the government in any way?
Yes, we get federal funding through Inland County's Legal Services. Actually, we're a sub-grantee, and we also get funding directly through the state bar and through the court system in order to provide our services to the low-income communities.
But you're not actually a county service, let's say?
No, we're funded. We're an independent nonprofit entity that's governed by a board of directors.
Okay, and Eulalio, how about yours?
Our entity is funded through multiple grants, LSC grants, state grants. We do receive some county grants. We get nonprofit grants. So, but we're not a entity of the county nor of the state. We're also an independent nonprofit, and with that, we litigate on different issues.
Okay, now I just want to let you know there's so much information I would like to ask and have you bring out, but for our viewers, this is a really great set of panelists. They know a lot of information. I know we're going to get a lot of calls. We're already getting them. So I'm already going to go out to a call. So let's take our first call. Eric from Chino. You're on the line. It's your call. What's your question?
I own property and I am a landlord that is for rent. And what I've done is I've written into the lease agreement a 3-day pay and quit. And the tenant agrees to that before moving in. I wanted to ask your panelists if that is legal in their eyes.
And if I heard correctly, that's a 3-day quit. Is that right?
Well, I heard 3-day pay or quit,
Right.
which is actually what the law is. Under California law, and this isn't necessarily a foreclosure question, it's just that if someone doesn't pay their rent, a landlord has to provide a 3-day notice to the tenant to pay the rent that is owed within those 3 days. If the tenant does not pay the rent owed, on the 4th day, the landlord could initiate an unlawful detainer action. And so since that's the law, I don't really see the purpose of putting it in the lease. However, if what the caller is asking about is a situation where they want to be able to force the tenant out without having to go through a legal process, that is definitely illegal. In California, you need to go to court to get a judge's order in order to evict someone under any circumstances.
So even in the case of a 3-day pay or quit, if they don't pay in the 3 days, you still have to go through the unlawful detainer. I want you to highlight what that means for us, but first I want to ask how it relates to tenants that are in units that are foreclosing. I've heard from reputable sources in the news that up to 1/3 of the units being foreclosed, both single-family and multi-family units, have renters at the time of foreclosure. So can you tell me, are they evicted at the time the unit goes into default or when it forecloses, or when is the tenant thrown out?
The tenant cannot be kicked out at the time of sale. The new owner still has to go through the unlawful detainer process. You still have to serve the tenant with a notice. Okay, they have to go to court. They have to get an order, and the sheriff goes out there, posts a notice on the door to say they have 5 days before they're removed from the unit. But you still have to follow the whole judicial system in evicting a tenant.
Now, if I heard you correctly, that means 5 days from the time of sale, they can be evicted. They'll get a notice. And I know there's some qualifiers on that. So elaborate for me. Is it 5 days or is there more time?
No, what happens is, let's say a property has been foreclosed on. Before May 20, 2009, okay, the new owner has to provide a 3 and 60-day notice to the tenant. 60-day notice for the tenant to be removed from the property.
Okay. A 60-day notice.
60-day notice, okay. After the 60 days expires, the new owner has to go into court with an unlawful detainer, file it, serve the unlawful detainer on both the owner and the tenant, okay. And they have to do personal service, but there's requirements that they have to do. The tenant has the right to file an answer within 5 days from the service of the complaint. They go to trial, okay. At the trial, the judge decides who is entitled to be in possession of the property. Thereafter, the owner gets a judgment takes that judgment to the sheriff's office, gets a writ of notice. The sheriff's office then goes out and posts on the door of the property that the person occupying the property has 5 days to leave the property, and they'll change the locks on the 5th day. And usually that occurs at 6 o'clock in the morning, okay, on the 5th day.
So, okay, let me ask about this changing of locks thing, because that's something that we've heard from a lot of our viewers that are concerned about the foreclosure process. They know that, for instance, the owner of the unit is in default. It hasn't sold yet. It's just in default. It's not sold yet. But they're afraid that they're going to come home and the locks are going to be changed by the bank or by the lien holder or by the sheriff, and they're afraid that they're going to find their stuff on the curb or that they can't access it. Is that possible? Is it legal?
Well, it happens, unfortunately, but it is definitely illegal. Usually it's not the banks that do it, because the banks have, a lot of attorneys that understand that it's illegal. If it does happen, the proper thing to do is to call the police. Every police officer knows that it's illegal, and they will contact the owner of that property and get them to reopen the doors and tell them, you have to go to court to get an unlawful detainer, to get a unlawful detainer order to regain possession of this property. Every police officer knows that. So that's always, when clients come to us and that's a situation, the fastest way to resolve it is to call the police, and they will take care of it. And like I said, it does happen. There are people that break the laws frequently. It's something that doesn't happen as often as some other criminal activity, but it does happen. It does happen, and so I always tell our clients, you have to, don't be afraid to go to the police and get them to help you. And then, since it is against the law, they could then sue the owner for unlawful eviction, which is an illegal action. It's like any other damages that they've suffered for any wrongdoing that was done to them.
So let me clarify if I can. You mentioned that it does happen, but it's illegal, so it doesn't happen very often by the banks because they have their attorneys.
Sure.
So is it a fair statement to say that when it does happen, it's actually happening on the part of a landlord or an owner changing the locks as opposed to a lien holder?
What we have seen on several occasions is that the previous owner who stopped making the mortgage payments, who lost the home to foreclosure, who is trying to squeeze every drop of blood out of their tenants, take all the money that they can, they're then taking the illegal actions even after they've lost the home to the bank, or sometimes even before they've lost the home. The tenants start getting a little nervous. They're seeing these notices posted by the bank. They try to confront the landlord. The landlord sometimes tells them, hey, there's nothing wrong. But the landlord is trying to get away with something by forcing them to pay and using those types of tactics.
Well, then let me ask a follow-up question. If there's a notice of default on a home, but it's not yet sold or repossessed by the bank, can a tenant that's occupying the home stop paying the rent?
No. They still have to pay the rent to the owner. The owner is still entitled to the rent until the point he loses title to the home. Okay. And even then, right now, with the new law, they should put the money in some type of bank account, because the new owner bank would have to honor the lease based on the new law. So they should put their money in a bank account to show good faith. So when they come in front of a judge and the new owner, the new bank says, well, they never pay anybody rent, they have proof to say, look, we have the rent in this bank account.
Okay, I'm going to jump out to the phones again, even though there's lots of follow-up questions.
That's good.
I'm hoping our viewers will ask these follow-up questions. So let's jump out to Rancho Cucamonga. Robert, it's your question. You're on the air.
Good evening. How are you doing today?
Good. Thank you, Robert.
My question is this. If you are renting a house from the landlord, and the house goes into default, let's say, and the landlord's behind 6 months behind on mortgage payments, can the landlord does the landlord have the responsibility to notify the tenant that he's in a default, and can he continue collecting the rent from you if he's in default?
Okay, good question. That's similar to what we asked about whether the tenant has to pay. But is there a duty of the landlord to notify the tenants that they're in default?
There may be a duty.
A legal duty.
There may be a legal duty, but I'm not sure about that. But what I am sure, okay, the tenant still has to pay rent to the owner. They have no excuse to tell in front of a judge, look, I think the owner is going to foreclosure. Why should I pay? A judge will look at that tenant saying, the reason they're going to foreclosure is because you're not paying that rent. Okay, so judges look really harshly on that issue. You cannot live in a place for free. Okay, you have to be excused judicially by an order saying you're not obligated to pay any rent. And there's process for that, but you don't want to take it upon yourself not to pay rent. You need to pay rent. If you have any doubt, you need to put that rent in some type of bank account. You cannot just stop paying rent.
Okay, so as a follow-up to that question, if the landlord does not notify the tenant, when would a tenant of, say, a single-family home or a multi-unit find out that the ownership is being transferred through a foreclosure sale or a bank repossession? When would they find out?
Well, usually what happens is that there are notices posted on the property, or there are things received in the mail. But let's say a person doubts that the person is the owner. They could check the county recorder assessor's office to see if there's been a change of trustee. Because there's different notices for that, and I don't know the specific notices. But they could check the county recorder's office and say, is there a new title to this new owner? Or like I said, really have an issue, they could put the money into an account. Okay, that's the safest way.
When you say an account,
a bank account.
But do you mean just put it in the account kind of as a self-directed escrow and not give it to the landlord? Or you put it first in the account and then issue it to the landlord?
No, what you want to do, and there's different mechanics. So I'm just going to say generally, okay, but there's different processes. What you want to do is create a separate account saying this is for rent, okay, and put the money in there in trust and say, look, I have some doubts that you may not be the owner, okay, but you want to put money into an account, okay.
To show the good faith.
Show good faith. And
All
that's
right.
the best thing. Property, there will be some notices posted on the property. There will be information mailed to the property. But, I mean, people have a doubt. They can check the county recorder's office, but they need to somehow put the money away.
Okay. I'm going to go to another caller, and we're getting a lot of calls already. Paris, I'm going out to you, and the name is Son. You're on the air. What's your question? Son, can you speak up for us?
Hi, good afternoon.
Hi, Son.
Basically, I am 3 months behind my mortgage. I have been dealing with the bank for doing a loan modification, and the banks are not responding. I'm basically upside down. I owe like a 380, and the house price is about 150. And I'm trying to do the loan modification to save my house, so I don't need to damage my credit history by doing a short sale or some sort. But if the bank are not responding, will the house will automatically go to the foreclosure?
Good question. Alan, I saw you taking notes. Do you want to take that?
Well, as far as the percentage of from 380 on the mortgage to a fair market value of 150, the bank is probably not responding because they're not going to reduce the principal on the mortgage that much. I mean, that's not in their behalf right now. What makes business sense for that specific case in the bank's going to try to take the house back and wait for it to increase in value. That's been noted in banks' techniques right now. But when you talk to the bank, hopefully the bank will tell you what can you afford as far as a payment, and if it doesn't address a $380,000 mortgage, it's going to go in foreclosure. Unless they can reduce that principal, you're too far upside down.
Alan, before we go to another caller, what I'd like to know then is if the bank forecloses on the home, they're either not going to get anything for it if they let it sit, or they're going to sell it at the then market value, which is the very low value that the current owner wants them to renegotiate. So why not renegotiate with the current owner instead of selling it at the fair market value, in which case the market forces them to lower the principal?
Well, they're going to go ahead and foreclose. If they foreclosed, and to answer your question, they're going to get a real estate agents or a service company to try to sell it for more than they could possibly have from the owner saying, look, it's worth $150. Suppose they're able to get another $220,000 for it instead of that $380. It's in the bank's behalf to go ahead and put it back on the market and see if someone else will pay more for it.
Okay. All right. I'm going to jump out to another call. Let's go to Pomona. Maggie, it's your call. You're on the air. What's your question?
Yes, hi. About a year and a half ago, I accompanied my friend and her husband to court. He was in court because the tenant took him to court because he was not making mortgage payments to the bank, but he was collecting rent from the tenants. Anyway, the judge gave him 5 years in prison and said that it is illegal to collect rent and not make mortgage payments, and he said that that's called skimming. So he's in prison right now for skimming, whatever that is.
Okay. Enrique, does that sound right to you?
Skimming is against the law.
Describe what it means to you.
It's a type of fraud. It's you are taking money from someone when you have a rental agreement with someone, and this hasn't necessarily played out in landlord-tenant law. It is a criminal violation, which is why this person went away for 5 years. But in landlord-tenant law, a tenant has to guarantee. It's called the covenant of private enjoyment. And not to get into technical terms, but the landlord has to guarantee the tenant has full and unrestricted access to that property. And so if the landlord is losing the property to foreclosure, then that's interfering with the tenant's ability to feel like, hey, I'm paying to live here, and to live there freely and without any problems. So we don't personally, at my organization, deal with criminal law, but there are some criminal statutes, fraud-based statutes, that do address the issue, and skimming is one of them. It's when you're taking money from someone and really you're not following through with some of the duties that you have to them to ensure that you're securing that rental property the way that you should.
Okay, now that's kind of a hot button because what we've heard already is that the tenant has a duty to pay to the current owner.
Correct.
And that even if the home is in default, the tenant has to pay. And that if the home is in default, which doesn't mean sold yet, that the owner has full possession of that property. The bank cannot legally come and change the locks or do anything else. So in that case, is it skimming? Or is it just the tenant paying for a home and the owners will eventually lose it? And in fact, if they do lose it, then don't the tenants have the ability to live there if they've paid rent for 30 days worth of time? They can't be evicted for 30 days. They can't be evicted for 60 days. Isn't that true?
That is correct. And I think it is really important to recognize that we're talking about two different systems of law. We're talking about criminal law, which is governed by totally different set of statutes, and landlord-tenant law, which is what most legal aid organizations have the experience in working in now. I would recommend to our clients to go try to file something with the district attorney's office. They're the only ones that could file any criminal complaints. The chances of getting a DA to take a skimming case are pretty low. They're usually focusing on much larger issues. And so it's very surprising that in Pomona that the DA in Los Angeles actually took a case like that. It's good because it is against the law. There are some laws out there that some DAs don't focus on as much as other laws, like violent crimes and things like that. But I think just to add on the advice that we were giving earlier on, if you're in a situation where you're with a landlord who is losing the home, pay that rent or set it aside and just make a note of everything in letters. Create some paper trail to protect yourself if it ever comes to the point where you have to go to court. Again, that landlord, they may come around and try to bother you to get you to pay. They may threaten you. That's against the law too. Because you have the right to enjoy that property as your own, the landlord just can't come in and bother you. So you need to be assertive about your rights and not let the landlord intimidate you. Now, if it does come to the point where they're trying to evict you, then you have those 3 days to pay. And you could also go to court and convince a judge that because the landlord wasn't complying with their duty to protect the home from foreclosure, that the judge also has the power to reduce the rent. Now, some judges are very, very conservative in some areas, and they're very, very unlikely to do it in some situations, but they do have that power. They do have that power, and so that's the difficulty. It's like, we're trying to help our clients, but it's the judges that have the ultimate power, and each of them have their own ideas of what's right sometimes.
Okay, Alan, I know it looks like you want to follow up, but I'm going to jump to another call. Name of the show, it's your call. So let's go out now to Desert Hot Springs. Thank you for waiting. Carla, it's your call. What's your question?
My question is that we live in a complex of 10 apartments, and the owner lost the billing to foreclosure, and he collected all the deposits. What about the tenants getting their deposits back? And now the bank owns it, so we are paying rent to the bank, or who has a realtor that is collecting the rent?
Good question. It sounds to me like there's a high level of anxiety and uncertainty when they know a unit is transferring ownership through a foreclosure. So they're worried about who's going to have possession of their security deposit, even if they're paying rent and still keeping up with their lease or month to month. Does the new owner have the security deposit to give back? Can the new owner say, I never received the security deposit from you, I'm not going to pay you back your security deposit when you leave, and you'll have to sue the old owner? What's the process?
Well, that's exactly the process. I think,
Go ahead.
Just that, you can't do anything against the bank. The bank does not have the security deposit. And so really the only way that tenants could, get their money back is by suing them. Now, under California law, a landlord, once a tenant moves out, has to get their security deposit back in 21 days. If the tenant does not receive that money back within 21 days, then they could sue the landlord for triple the security deposit.
Which landlord?
The original landlord, the landlord that lost the home. Now, there are obviously going to be some logistical problems. Where is this person? Are they hiding out somewhere? But that is the person that they would have to sue, the original owner of the property, who took their security deposit.
So my takeaway from that, quite frankly, is that in this case, the renters are highly disadvantaged by the foreclosure, despite all of these new protective laws that have been put in place. The maintenance of the leases, the 60-day guarantee before any eviction process can even begin, all of those buffers to make sure people aren't thrown out, they could still potentially have to fight to get back their security deposit.
Yeah, they most likely will have to fight to get the security deposit. There may be nuances just to add to what Enrique said, there may be some responsibilities with the new owner, but there needs to be more research on that issue, okay? Because there may be some responsibilities that the new owner may step into the shoes of the old owner for different responsibilities. That's what the whole lease process too, with the 90-day law about the federal law saying that if the property is sold after May 20th and there's a lease, well, the new owner have to honor that lease. So it may go along, and I'm not sure, that they may be responsible for the security deposit as well, because they may be stepping into the shoes of the old owner and for all responsibilities as well. So there's something that needs to be explored. I'm not saying that I know all the answers to that issue, and they need to contact an attorney to get further review of those different responsibilities for the new owner as well. But it does take a fight to get money back.
Alan, before the show, you happened to mention something to me. Talk a little bit about cash for keys and some of the other options that tenants might have.
Well, the cash for keys, especially on the foreclosure end of the conversation. Right now, if the bank forecloses on a property, we have a tenant there, or even the homeowner is still there, they try to tell the homeowner or the tenant, look, I don't want you kicking out the walls, which cost a lot of money. I don't want you throwing the toilets out in the back or in the front yard, breaking out all the windows. We're going to give you X amount of dollars, enough to help you move, maybe new security deposit if we're going to a new place. And if you leave the place in a broom clean condition, or at least a condition that we don't have to go and make any unnecessary repairs, wear and tear is fine, we will give you some money, you give us the keys. And it's a good incentive, because sometimes people get a little bit upset when they lose the house. And they have guys like me as an appraiser going in, I'm looking around, and I said, when did they start doing the modification of the home here, which is pretty tough. And of course, it's a loss for the bank. So hopefully, if someone's going in foreclosure, be proactive on this, even a tenant. You know this is going in there, contact someone when you get a notice on the door. Can you go ahead and I'm ready to leave it in good condition. Can you help me moving to a new place? And see if they can go ahead and help you out on that.
Okay. All right. So we have more questions about the 90-day. If I don't get to it, bring it up in a moment. But I am going to take another call, so let's go out to San Bernardino. Jeff, it's your call. What's your question?
Guys, I'd like to know just what percentage of loans would you say are bad loans, loans that should never been...
Ouch. Well, we got the gist. So go ahead and answer. What do you think, Alan? Alan, you're involved in the fraud part of it.
Oh, sure. The Fannie Mae made some studies, and basically they just threw out subprime loans. About 50% were fraudulent. Fraudulent being affected by predatory lending. They just threw out some numbers. Does that mean 5 out of 10 people got ripped off? It would depend on newer statistics, but right now I'm hearing a lot of homeowners saying, I didn't understand this. Now, does that classify as getting ripped off? Yes. But if they can prove they didn't understand it with a bait and switch on the contract or something like that, then we're going to have a lot more people than we see right now.
But how much of that is kind of buyer beware? The buyer didn't do the due diligence. The buyer participated in the liar loan process. Okay, well let's get down to that. Let's say we had 10 people out there. Out of those 10 people, homeowners, we had a mortgage broker, independent mortgage broker, who basically liked to bait and switch on contracts. He did the same situation to 5 out of those 10, the same thing. The same notary he set up that supposedly not supposed to tell you how to sign this document. They set the same notary up. He did the same bait and switch. They're ready to move in the next day. Oh, we got some new paperwork for you. Just sign right here. They leave a paper trail. So yeah, it affects a lot of people. Okay. Enrique, it looked like you had a follow-up, and if not, I'm going to take another call.
Not really. I'm actually just really surprised at the numbers. You know, we get, in legal aid, we get so caught up in kind of like the individual cases of our clients that, you know, it's nice having Alan here to give us the big picture.
Okay, great. So let's go out to Camarillo. Jerry, it's your call. What's your question?
Yeah, my name is Jerry Montalongo. I'm a real estate broker.
Hi, Jerry.
Hello. My question is, how does it affect people that are losing their homes with this new law signed with Governor Arnold Schwarzenegger as far as the California Foreclosure Prevention Act that pretty much tells people you can stay in your home for the next 90 days unless your lender, ABC companies, files that they have some kind of a program that prevents foreclosure?
Yep. Jeff, familiar with it? Alan, I know you are. You were talking about it just a little bit ago off the air.
We all kind of talked about that.
Absolutely.
And
fill us in.
Sure. So we'll all jump in at one time here if you want. The situation being is if the lender has made some efforts, like 30 days prior to filing a notice of default, they can go ahead and show the state and get an exemption on that 90 days, showing that they were in compliance of trying to work with they have an existing program that's in compliance with this law.
So that's how to get an exemption. Back up and recap for us, what is this 90-day, and distinguish it from what I heard, the 90-day tenant law versus the 90-day moratorium on foreclosure. Tell us about the 90-day moratorium.
That was the 90-day moratorium. If the lender can go ahead and apply for exemption with the state of California, that 90-day moratorium will not be applied to their current mortgage client.
So, and I'm sorry, just to clarify, what we're really talking about is that it's from that notice of default. From that notice of default date, which is the first public notice that this mortgage is not being paid, it's something that is recorded at the county recorder's office. It's from that date. The normal process, and correct me if I'm wrong, is 3 months before they could set a sale date after that notice of default.
So there's already, moratorium aside, a 90-day wait between the default notice and the sale notice.
Exactly. And so what this new law does is that for homes that are owner-occupied, for homes that have loans financed by companies that do not have what's called a comprehensive loan modification program, which is, it's very up in the air, you know, what exactly that means at this point. For, in those very limited circumstances, the homeowners are going to get an additional 90 days theoretically to give them more time to try to work out some kind of a deal. And again, there's a lot of loopholes in it, in that banks can go to the state and say, no, we have a comprehensive program, so this 90-day notice shouldn't apply to us. And they're going to get certified by the state one way or the other. And there's going to be some companies out there that have that loans that they own will get the extra 90 days. There's going to be some companies out there that won't get the extra 90 days when they foreclose. And so at some point the state's actually going to post, a listing of those banks.
It's fair to say that the major banks will claim to have a comprehensive program in place.
Exactly.
Even though they don't return the lender's calls or act on doing a modification, they have a program in place even if the program stalls the lender.
Absolutely.
And stalls the homeowner.
The state has a list right now of some of the lenders that have been exempt. And you have to get on the state list or the state website. I want to say Secretary of State, but you can just go on the regular state website and they will direct you to that. And they have a list, and it's growing longer every day.
Okay, but there are some cases where people will now have 6 months after notice of default instead of the 3 months. That's fair to say? Or was it just entirely show?
I'm really not sure. I would really, all I can say is, lawyers' two favorite words, it depends. There's a lot more that you have to look into.
Sure,
It's just gone into effect. Right now it's kind of this open window period where the banks are applying to show that they're exempt from the law. And so we're really only going to know until sometime around the end of July who is going to be exempt from the law, or which banks are going to be exempt and which ones are not going to be exempt from having to give the owners those extra 90 days.
Okay. Shame we can't clear up all the uncertainty.
No, unfortunately, no.
Sticky process. We're going to go out to Palm Springs. Mary, thank you for waiting. And it's your call. What's your question?
Hello?
Hi, Mary. What's your question?
Well, I'm noticing all your people here on the television. Oh, you the one? I'm talking. The TV's behind, right?
Yes, and I want you to go ahead and talk into the phone, not the TV.
What I'm saying is, these people losing their homes. I don't understand how they buy a home and they can't pay their home. Okay, either they don't have enough money or they buying a home just to show off. Is that what's happening? That's why they can't keep their homes and they go into foreclosure?
Okay, thank you, Mary. We saw that the question that you wanted to know is why, when somebody is in the position to buy the home, don't they have an attorney, because they have to pay the escrow and the closing costs and all these other costs. Why don't they also pay an attorney to advise them on the details and nuances so that there isn't this I didn't know what I was signing problem?
General question?
General question?
Oh, yeah, general question, sure. First, they're trusting the real estate professionals because they have a license, the real estate broker, real estate agent, mortgage broker. If they're working for a real estate broker who has a mortgage license, they're trusting these people to go ahead and give them the mortgage that they want, or at least they can afford at the time. And sometimes what we got caught in right now, from 2000, let's say 2002 to 2004 to 2004 to 2006, this is a bad mortgage, but guess what? You can go ahead and refinance in 2 years, or you can sell your house in 2 years. As long as the prices were going up, no one was hurt. We hit 2007, then we hit the brick wall.
So, not to accuse anybody, but are you suggesting that everybody acted in good faith based on the information at the time and nobody really expected the scope of this? Or did enough people really just not act properly and cause this effect?
Let's say that they were able to manipulate the system a little bit.
And we're talking more about the real estate brokerage lender side
we're
than we are the Wall Street
we're talking about
and the collateral debt obligations.
Absolutely. With the existing programs we had in place, it was easy, as you say, no doc loans or very, very low doc loans. It was easy to go ahead and take advantage of the situation and be in compliance.
And there's really no accountability, real estate license or not, by those brokers. We aren't seeing these brokers being held to account. Mostly, it's fair to say, I think, correct me if I'm wrong, because they gave paperwork to the people that signed. And as long as everything's in writing, really it becomes that buyer beware situation.
Buyer beware, but if we went back to this prior conversation, if we can prove that the broker shortchanged the homeowner, either by documentation or changing the mortgage around, a little bit of sign this blank, don't worry, I fill it in, and we see 5 or 6 people being addressed that same way by the same mortgage broker, we're seeing little trends here, and that's what I try to look for.
Okay. Now we have another call. I'm going to go out to Rancho Cucamonga. Carl, it's your call. What's your question?
Yes, I am currently current with my mortgage right now. I have 2 mortgages with IndyMac Bank. I have a first and an equity line of credit. My income has dropped significantly, and right now we're renting out our home and we're renting in a senior apartment. I was wondering, there's so many companies out there that claim to help people in this situation. Can you give me any advice on what I could do? Right now I'm trying to get my loan modified through HUD, but it seems to be not going very far. I was wondering if you have any advice you could give me.
All right, so for Carl's benefit and so many of our viewers in the same situation, what are we actually seeing in the field? What's happening out there on the streets?
You get on the State of California Attorney General website, he will tell you not to pay anyone in loan modification at this stage because most of them is a high-pressure scam program. That's what his notice is saying right now.
And what about for the people that know that the alternative is that the banks aren't responding?
The only thing you can do is to try your own loan modification. Make sure you document everything with the bank. You send paperwork that has a good paper trail on it. You try to negotiate in a fair effort with the bank. At that stage, you should call Hope for Homeowners, which is one of our government programs. Let them work with you and interact as they do a 3-way phone call, which works wonders now and then to get the bank to respond. And that's been very successful with some of my clients.
And anybody else?
This one thing, no one can guarantee a result. And people should begin to realize that if someone's going to guarantee a result, they're lying to you because that can't be done. And I think people should need to consult an attorney to see what options they do have. Regrettably, some options may be that the property will be foreclosed, regrettably. But no one cannot guarantee a result. And so they should contact an attorney to see what options they have. There may be Truth in Lending Act violations. There may be other violations. But there is no guarantee. That's something.
Because the banks aren't required to necessarily respond and do any modification. You signed a loan, they have the legal right to foreclose. Is that correct?
That's true. All the government programs are a volunteer program by the banks.
And even on top of that, what makes this situation different than what it was before is the whole securitization, which basically means that mortgages are no longer held by the banks that made them. And so now sometimes it's not even the servicer that gets the final decision, it's someone on Wall Street that actually owns the loan that has to either approve or deny whatever offer to try to modify the loan is made. And so sometimes you've got layers of people that you've got to go through to get an approval for a modification. And so that's really what makes it complicated. The recommendation I would make is, in addition to talking to a trusted attorney, but also HUD-approved housing counselors. I know that this show's highlighted some of them. They're doing some great work out there, but even then, a lot of the modified loans, they're still going into default. People have to just be really honest with themselves. Can I afford this property? And sometimes, as Eulalio said, you have to. Sometimes foreclosure is the best option.
So in that case, the renegotiation, even if it were able to go through, might not give the relief necessary to have somebody that's upside down in their monthly income be able to afford the home. Mm-hmm. In which case, it's really not in the bank's best interest to make that modification. Is that fair to say?
Absolutely. And the individual, the homeowner, should really work out on paper, this is how much I can afford, and take that working budget and give it to the bank and say, will you approve this? Instead of running around for maybe 2 or 3 months and wasting this specific time, that the homeowner should consult an attorney and seek other options.
Okay, and just to be clear, the attorneys will ask for a fee typically unless they're affiliated with your organization, and that doesn't necessarily mean they're fraudulent.
No, I mean, they may have some type of fees, but And neither attorney or anyone else can, like I said, guarantee a result. They may just need a fee to just research the issue.
Sure.
But it shouldn't be an exorbitant fee. I mean, it has to be something reasonable.
So not everything is free, but if people are coming to the homeowners and asking for a fee, that's suspect.
Absolutely.
Yeah. Attorneys cannot go and look for a case. Okay. They cannot go to someone's house, look, I'm an attorney here, I'll get you this result. They can't.
Yeah, and I tell all my clients, call up an attorney, ask how much an hour of his time is just to talk this over. An attorney might give you some free consultation and might charge you for an hour of their time, which is well worth your effort on it than going out and seeking a friend's advice.
Let me also ask, you mentioned about the Wall Street investors being the true owner. How can people find out who owns their home? Say they're a tenant. How can they find out who actually, not the landlord, but who actually owns the home? Is there a way?
There's specific ways. You can go on the Fannie Mae Freddie Mac website and find out if they own that specific loan, and then you can go to your servicer currently and you can ask them who owns the loan. You have to write some paperwork on it, but it can be done. The easiest thing is to eliminate Freddie Mac and Freddie Mae, because you go on their website and enter in your loan information. They will tell you if they own it.
All right, so let's take another call. Let's go out to Lancaster. Joe, it's your call. What's your question?
Hello.
Hi, Joe. What's your question?
Hi. My question is, thanks. It's interesting listening to your program, but my question is, being a realtor and wanting to refinance my loan, I went blind in August last year. I'm on Social Security, and I can do a little bit of real estate, but remodifications, I seem to be having a problem finding my lender or anybody to do a remodification because of the fact that I'm 1099. Is there any kind of such things out there with lenders or anybody for this kind of a situation? I would love to keep my house, but if the economy stays like it is, it's going to get rough as it is now, just trying to make the payments.
Absolutely, Joe. Thank you.
The credit market's totally different today than it was 2 years ago. It's very, very hard to get a stated loan or a 1099 loan.
1099 being people that aren't on salary.
Aren't on salary, or I should say stated income loans. It's a just a totally different market, and the people with the money are the ones that set up the rules. The federal government has started tightening up also the requirements that they are now putting on banks to ensure that they're making sound loans. So they're also under some federal pressure too. So they're trying to fix this runaway credit giveaway that was in effect for 5 years or so.
But at the same time, there's a lot of homes that need to get snatched up. Well, let's go out to another call. Let's go to Ontario. Susan, it's your call. What's your question, Susan? Hi, Susan. We know the television will catch up. And for our other listeners on hold, do try to listen into the phone and not just to your television. Let's jump over to Beaumont. Linda, are you with us, Linda? What's your question?
My question is, if you go into foreclosure, and foreclosure is the only bad thing that you have on your credit report, when could you buy another house?
Great question. Wonderful. How bad is it? I mean, we talked about tight credit now, but say in 3 years, or is it one of those things that's going to follow you for 7 years, or how long will a foreclosure follow you?
To be honest, it's going to be on your credit for 8 years. Any negative credit information is going to be on your credit for that long. But if you do all the right things, if you start, establishing your credit, and showing good credit history as soon as the foreclosure is done, then you little by little start building. It's like any other negative credit history that you have on your record. I don't think it's every case is different. So I really can't. Yeah, it depends. It depends. So I really can't say it's going to take 3, 4, 5, 6 years just because every case is different.
Okay. So let's go out to Riverside, and it's Mr. Gardy. Is that correct? Are you with us?
Yes. It's pronounced Gotti, G-O-T-I.
Okay. What's your question?
Where can I file to get a homestead?
Oh, good question. Tell us about the homestead declarations.
That's county recorder's office.
Right.
What it does is it protects your. A homestead is a legal document that you file that you attach to the property at the county recorder's office. So it becomes a public record, and you show that it's your primary residence, and therefore it gets certain protection from creditors.
Like what protections do people not have if they don't file a homestead?
I don't know all the intricacies of bankruptcy law, okay, but bankruptcy law still protects your home. There are some protections regarding the home itself, if it's your primary residence. And that's basically try to protect you to have a place. You may also protect your car. There's certain rights there that I don't fully all know because I don't practice in that area of law. But like Enrique was saying, the homestead there to protect your rights against lawsuits from unsecured creditors trying to collect money from you. Because basically what happens, that's a major source of asset that you have, and that shields you from all those creditors with this homestead. But the bankruptcy laws, I think, have some protections built into it. Again, I'm not sure. Someone should consult a bankruptcy attorney for that. But
okay, so what I'd like to do is find out a little bit about how we can get more of the information that you have to our viewers. KVCR is building a website that's trying to consolidate the information. So is it fair to say that you'll provide us with additional information and we can get it on there, probably attached to this show as well as to the county resources? Mm-hmm. But let me ask also, what is probably the one thing that you encounter often that most viewers or most of the people you encounter are unaware, like your best tip for people to weather this storm?
Well, you have to be responsive to any legal documents you receive. I think a lot of people want to bury their head in the sand and try to avoid facing reality. And unfortunately, when you're dealing with such a critical issue as your home, your place of where you're living, you really have to act quickly. If you do not act, you're going to get evicted. It's that simple. That's the end of the foreclosure process. And even if you cannot pay your mortgage, you could always try to get more time by consulting an attorney. If you're low income, a legal aid organization that could try to delay that process as long as possible.
And there are ways. Okay.
I think one of the major things is that tenants should always ask for documentation. They should never pay for cash. That's what we experience when people are getting evicted. They say we pay cash. You have no proof. You should always ask for receipts. If the landlord doesn't want to give you a receipt, then you should probably go somewhere else. But you should always get a receipt, money order, anything else but cash. Even though cash is accepted, you don't know the other person, so you want to have proof. And I think when Enrique is saying you got to have proof, you want to act affirmatively, not defensively. Okay. You always want proof of everything that you do, written proof.
Alan, give us about a 30-second tip.
The best thing I can tell homeowners who've been involved, or at least they feel like they've been involved in predatory lending, save your current paperwork. I need all the paperwork you have. The other thing is start a log. Start because you're going to forget what happens to you. Okay, so you need to start that log on there and acquire the original appraiser from your mortgage company, their appraisal. You're entitled by federal law to get a copy of it. Get it.
And I just want to mention, we've talked a little bit about the banks. You also, to be fair to the banks, have mentioned that they're under federal pressure and they're under the constraint of having those the actual title or the actual ownership given out to somebody other than the investors. So I just want to offer, though, that we have asked, on behalf of our viewers, for several banks to come in and talk with us and answer the questions that we have and answer the questions that our viewer have. We've asked Bank of America, we've asked Chase, we've asked Wells Fargo, we've asked Union Bank, and to date, none of them have agreed to come in and talk with us or answer your questions. And I want to ask those banks to get a hold of KVCR and let us know when you're going to come in and talk to us and our viewers. Now, I want to thank our guests, Enrique Acuna, Eulalio Castellanos, and Alan Sims. Thank you for being here today. Tune in next week when we'll have more experts answering your mortgage crisis and foreclosure questions. I'm Roger Bowman, and remember, it's your call.
For more information about this project and related topics, visit kvcr.org and click on Facing the Mortgage Crisis.